merged with the GST. That I have just a verbal instruction that it is no more continuing, but I need a written instruction, Bhagat.
But 2010 matter, how do we adjourn a 2010 matter? Tell us.
Yes, Bhagat.
$15 years old matter of a repetition.
Bhagat.
And last occasion, there was no representation from the petitioner. 1/4/2025. Is there anything remaining to be adjudicated?
I don't think so. There remains anything. Bhagat.
Yes, what do you say?
I don't have the brief, my lord. I'm appearing on behalf of the council now.
We understand your predicament. You may not be having the brief also, but we cannot help.
Your Lordships, I am appearing on behalf of Ms. M.N. Havelia. Your Lordship, similar matter series is parted before the bench of Chief Justice at Principal Bench, Your Lordships. So the matters are expected to be listed in next week for hearing at Principal Bench.
Similar
So, Your
matter
Lordship,
means, what similar matters? How a matter of Arunachal Pradesh is listed there? What is the similarity?
Your Lordship, a similar matter, Your Lordship, in WPC.
What is the similarity? Kindly explain to us. What is the similarity? Simply saying similar will not do.
Your Lordship, the similar.
That matter is of which year?
Related to Arunachal Pradesh entry tax, Your Lordship.
That matter is of which year?
It's of 2018, Your Lordship.
Now this is of 2010.
Your Lordship, but it is related to similar matter, Your Lordship.
So what's the similarity? What is the similarity?
Your Lordship, it is related to entry tax of Arunachal Pradesh.
What is the nature of challenge?
Your Lordship,
What are the grounds of your challenge?
we are challenging the 2010 Arunachal Pradesh entry tax act.
What
Your
are the
Lordship.
grounds of challenge? What is the subject matter of the petition filed in the principal bench? You cannot have two challenges in two benches.
Your Lordship, we are challenging the validity of Article 301 of the Constitution, Your Lordship.
Validity of 301?
Validity of Arunachal Pradesh Act.
Your Lordship, the Entry Tax Act of 2010, it is ultra vires of the Article 301 of the Constitution, Your Lordship.
That is the subject matter of which you have raised in the year 2010. We are hearing this. You may file another case in 2018.
Your
Will it
Lordship,
prevent us from having this matter heard of 2010? And there is nothing remained to be adjudicated. New act has come in.
Lordship, in that matter, the Arunachal Pradesh Goods Tax Act 2005, there were some provisions of Entry Tax Act in that act. So we challenged that provisions of Arunachal Pradesh Goods Tax Act, which contained entry tax. So this matter was kept pending for such a long time, only because that matter has to be decided.
Now this will not be kept pending. If it was kept pending, it was done before. Now it will not be kept pending. 2010 matter, we cannot keep it pending because of 18 matter is pending. Sorry.
Lordship, then this matter may be kept for hearing. We are ready for the hearing, but only because this matter has been kept for so long, only for the main matter.
Madam, last occasion you are not even present. Last 4 occasions not present. Don't make this kind of submissions. You're ready for hearing. If you're ready for hearing, please argue.
Lordship, only because for the last occasion also, Lordship, the matter was adjourned only because to give the status of the hearing before the principal.
If you have not checked the order sheet, please do not make this kind of submissions, madam. We are not repeating. See the last order. Yes, what are your grounds of challenge? Yes, who are you? What are your grounds of challenge? You have your seat.
may be kept next week. We'll come for the full hearing in that case, Lordship, because next week.
Sorry, 2000 matter, no adjournment.
But Lordship, this matter, Lordship may kindly see the Lordship previous orders in which this matter was kept pending only because the previous orders. which
We
has
have
been
seen the
up to this
previous
case.
order. We have seen the previous order. Now we are going to take up the matter for final hearing, 2010 matter. In 2025, please do not ask for an adjournment.
Lordship, we are not asking for an adjournment only because.
Then
this
please
matter
do
is
it.
pending.
Do it.
No, Lordship,
Similar
we are
matter is
not
pending
asking for
before
an
DB here.
adjournment,
We
only
are also
because-
DB will decide the matter. Matter ends there.
Lordship, we are only asking for an accommodation because the matter is.
We have been
pending before the-
accommodated long time, 15 years we have been accommodated, not now. Either
Lordship,
you argue or we dismiss it for default if you are not
Lordship,
pursuing the matter.
Lordship, when the similar matter is pending before the Lordship division bench of the principal bench, Lordship, this matter can be tagged along with that. It can be sent to that matter and the matter can be tagged along with that matter.
Rejected. Please argue. We are not repeating. If you are not arguing, we are going to take up the matter by our own. No need of any assistance from you. Yet, what are your grounds of challenge? Who are you?
Today we are not prepared, Lordship, because my senior is not well. So did not prepare for this matter today, Lordship. Because we were thinking that the earlier the matter has been adjourned only for on the ground that the matter is.
Please do
parted
not
with-
repeat. We are not there. Sort of hearing. You have repeated 3 times. Earlier it is adjourned, earlier it is adjourned. See the order sheet last occasion. 3 dates you are not even present. And 2010 matter, if you adjourned earlier, now you are not adjourning. How do you adjourn a matter of 2010? Tell us. Only because the 2018 matter is pending? Is there any logic in your argument? A matter filed 8 years after this matter is pending and therefore this matter also should be adjourned. What is this kind of prayer?
My Lordship, earlier also this matter was kept pending only because.
Now we
the
are not
previous-
keeping pending. We cannot repeating. Yes, please, if you do not argue, we are going to take up the matter.
Last time
Yes,
when we came
Mr.
for the hearing, when we came.
Mr.
for the
Ratan,
hearing
they
of
are
the
not
matter-
interested in arguing. Please say what
Lordship,
you have.
last time when we came for the hearing of the matter, Lordship, the matter was not heard.
Madam,
because-
please do not narrate anything which is not relevant to the facts of the case. If you want to argue on the facts. We are going to hear you whatever time you want.
Lordship,
Otherwise,
on the
please do
last
not say any
occasion-
irrelevant thing. Last occasion, what had happened?
Lordship,
Yes,
the
please.
last occasion, the order said that by order dated, the matter was ordered to be listed after the 6 weeks awaiting outcome of a batch of writ petition with WPC number so and so as a lead case. Lordship, may kindly see the order dated 10/4/2025.
How can a 2018 matter be a lead case in a 2010 matter, madam?
Because Lordship, this matter, Lordship, when it was filed in the year 2010, it came very late, Lordship. It was listed after 2018. That is why, Lordship, the Chief Justice also gave an order that this matter will wait the outcome of the batch of writ petitions with WPC number. We have prayed many times,
Okay,
Lordship, that
okay,
this
we have
matter
heard
will
you.
take-
Okay, you don't want to say anything on merits. Okay. We are closing your arguments. Yes, Mr. Ratan.
For that,
Yes,
Lordship.
madam.
Today not prepared.
What-
Only my only submission is that, Lordship, last order also.
What is
Lordship,
this? What is
We
the
are
matter?
awaiting the outcome of
My lord,
batch of writ-
basically they were challenging the Arunachal Pradesh Entry Tax Act 2010 now. And as per instruction,
Who are the petitioners?
petitioners,
Lordship, only for this date, Lordship may pardon, and Lordship may fix any date, we'll come and do the hearing. Lordship, the hearing on the online, it is not possible. We'll come and do the hearing if Lordship, I thought ki last occasion also, it was fixed only to inform the outcome of the
Yes.
bench. of
Who are the
petition.
petitioners?
That is why, Lordship,
petitioner is Patel Engineering, my lord,
Lordship,
So,
last occasion.
It's a
also it was
company.
fixed
company.
outcome. Lordship, last occasion also it was fixed only
They
for
were
the outcome of
executing
batch. That is why
coming
Lordship,
hydro
we are not
project.
prepared. We'll come. Lordship may fix on any date. On Friday also, Lordship may fix. We'll come and do the hearing, Lordship. Lordship, it cannot be done online in this manner. My senior is also not available today. Lordship, on Friday, Lordship, the matter may be heard.
It's a company. There's only one petitioner.
Yes, ma'am.
Okay, then what is the,
They were carrying out
Lordship, in this matter, designated
hydroelectric
senior from
power
Supreme
project, my
Court
lord,
is
in
also
coming.
appeared.
Okay. They were allotted some works or what?
Yes,
3 works.
3 works, package 1, 2, and 3.
Three packages.
3 packages.
Then
Lordship may keep it parted. Lordship, my senior advocate from Supreme Court will reply. Lordship, either tomorrow also, Lordship may fix the matter. Will ask the senior advocate to appear.
Now,
What is section 8? Where is the act? Where is the Entry Tax Act of
entry tax
2010?
act, my lord. Fine.
You have a copy of the Entry Tax Act? Is it part of the petition?
Yes, my lord, page 144.
144. Yes,
This is the entry tax act.
the entire act has been
Entire act has been
challenged.
challenged.
What are the grounds?
Grounds that,
Competency is ground, no.
no, my lord.
Then,
Grounds is that it is the earlier challenge to the Goods Tax Act, Arunachal Pradesh Goods Tax Act, what was struck down by this honorable court. They have tried to fill it up by this Entry Tax Act.
okay, that is the main ground. What was the earlier act?
Arunachal Pradesh Goods Tax Act, 2005.
Goods. Arunachal Pradesh Goods,
Tax Act,
2004,
5.
2005, struck down by this court.
Yes, my lord, the section 3(2) was struck down.
Okay, we'll have it tomorrow.
Yes,
Let us have the accommodation, but tomorrow you come prepared. Tomorrow,
Yes.
no
Lordship,
accommodation.
Lordship,
Madam, tomorrow.
Lordship, day after tomorrow, Lordship, Friday. day
Tomorrow,
after
not tomorrow. Day after tomorrow, we have got matters fixed.
Lordship.
A prayer for adjournment has been made on behalf of the petitioner. However, we have noticed that this writ petition is of the year 2010. And in the meantime, almost 25 or 15 years have passed.
Lordship, this
The
matter was waiting for
order
2018.
When the
2000
matter was, please do
But
not
judgment
disturb while we're dictating the order, madam. No, the
Sorry, Lordship.
minimum decency.
I'm so sorry.
When the matter was taken up on the last occasion, that is 10/4/2025, there was none to represent the petitioner. And this court had observed that even on earlier 3 occasions, that is 21/2/2024, 3/10/2024, and 4/10/2024, the petitioner was absent. This court had also made the following observation, paragraph 4 of 10/4/2025. Para? Be that as it may, and for the interest of justice, a day's accommodation is granted, directing listing of this matter tomorrow for admission. Full stop. It is made clear that no further adjournment would be granted in this matter, which is exceptionally old.
Always.
Tomorrow.
Always.
Item number 4. Smart. So, my lord, I have been informed that respondent number 3, 4, and 5 has filed their counter affidavit yesterday, and I am yet to receive, my lord. So since
3,
they.
4, and 5 represented by whom? Okay.
We have filed, my lord. We have filed.
What is the matter, Mr. Modi?
My
What
lord,
is the subject matter?
my lord, the matter is pertaining to the challenging of the business meeting conducted by the IMC. So the main respondent parties are the IMC.
IMC means Itanagar Municipal
Ah,
Corporation.
Itanagar Municipal Corporation. So,
Your
my lord,
standing counsel, Mr. Jamu, what is your stand?
my stand is paragraph 6, my lord. Actually,
There is one, this Arunachal Pradesh, this,
You have filed your affidavit yesterday. Would you let him have the instructions?
At-
If you would like to file any rejoinder,
My lord,
can- you-
I
you
will,
can-
I will go
I
through.
will grant you 3 weeks time.
My lord, if so.
Madam, you are appearing for,
1, 2, and 5, madam. We will
would
not
you like
file,
to
madam.
file affidavit?
No, madam, we will not file, madam. We'll go by the affidavit filed by 3, madam. 3 के लिए क्या नहीं है?
The Sri T. Jammu Learned Council representing the Itanagar Municipal Corporation and two other respondents.
Yes, ma'am. 2 other.
hello,
Uh,
I am the main respondent.
Standing Council Itanagar has submitted
4 and 6.
that affidavit in opposition has been filed yesterday. Para. Sri C. Modi Learned Council for the petition praised for and is granted 3 weeks time to obtain instructions and file rejoinder affidavit if so advised.
Oh,
Yes.
May I please your lordships? Lordship, this IA is for condonation of delay, lordship.
Notice was issued here.
Lordship, they have, in fact, they are appearing, lordship.
Criminal appeal.
This is criminal appeal, lordship. IA is in connection of
Conviction under
376D, lordship. A regress imprisonment for 20 years. lordship.
regarding the arraying of parties, are you required to have the victim as a party?
Lordship, the informant is appearing, lordship,
So informant is appearing.
appearing.
Okay, any objections by both of you?
No, Lordship, this is, as long as this is jail appeal, Lordship, we have no objection.
Is it a jail appeal?
Jail appeal, lordship. I've been appointed as a legal aid counsel in this case.
Or Sri J. Genie Learned. Amicus or legal aid counsel? Amicus or legal aid counsel?
Lordship,
America's first.
Amicus or legal aid counsel? Amicus.
amicus, lordship.
Learned amicus curiae for the applicant who has filed this application under section 5 of the Limitation Act 1963 for condonation of delay of 1027 days in preferring the connected criminal appeal. Full stop. Notice was issued on 19/4/2023, pursuant to which the respondents have entered appearance. Full stop. Both Ms. L. Hagi, Learned APP, and Ms. Sunso, Learned Legal Aid Counsel,
Yes, my lord.
for the respondent number 2, have fairly submitted that since the appeal has been preferred from jail against an order of conviction, they would not have serious objections in the aspect of condonation of delay and would rather oppose the appeal on its merits. Full stop, para. It is a settled principle of law that while adjudicating an application for condonation of delay, a pragmatic and justice-oriented approach is required to be taken. Full stop. We have also perused the averments made in paragraphs Which paragraph? Oh, yeah, it was there an application? There was,
Here is a lordship.
where
There
is
is
the
a,
application?
IA number 27 of 2023.
Which paragraphs have you stated?
3, lordship.
Averments made in paragraph 3 of the application. Whereby
3 and 4, lordship.
3 and 4, whereby the delay has been thought to be explained. Full stop. upon perusal of the same and on considering the nature of the appeal, we are of the opinion that the delay in preferring the appeal is liable to be condoned, which we accordingly do. Para, I accordingly stands allowed. Para, let the appeal be registered and listed for admission.
Lordship may call for the trial court record for
No,
paper.
appeal has to be admitted first.
Lordship,
It will come for admission.
yes, Lordship.
Lordship.
Apply.
Number 6.
Mayor, on the last occasion, my lord, our joint director was directed to prepare a report and submit it before this honorable court. Now, I have spoken to my joint director, but he has some problem. He has undergone spondylitis surgery. And so he has a problem.
Okay, we'll grant for some more time. But if the joint director is not there, somebody will be there in his
Deputy
place.
Commissioner will be the right person.
You get the instruction from the deputy commissioner.
Well, I'm studying council RD, my lord, deputy commissioner.
Madam, Pangu, yes, get the instructions. What is the matter? Pierre,
Matters for the construction of community hall.
okay.
Deputy Commissioner.
And the issues was it was not done under the geotech and it was shifted. It was shifted to the other place. They have done that.
That community hall, the site was shifted from one location to another location.
Yes. Not
That-
according to
That is the
geotech.
reason of your grounds of your challenge.
Yes. And not the structure, the community of the structure is not at par with the
Plan.
plan. That was the issue.
Yes, Mr.
And this has been, my lord, it has been long time. And now also they are
Mr. Pangu,
triggering
we are appealing.
and it was
I'm preparing for respond number 1, 3 and 4. Yes, my lord.
Who will respond to the allegations?
Last time, my lord, as per 8-4, the honorable court has directed the joint director RD to make an inquiry.
So deputy commissioner has constituted a board and my lord, there is a board report. Mayor,
it's not a matter of a week or a month. It's nearly a year that they are taking, just lingering.
You file your affidavit.
Yes.
right? Yes.
And honorable court,
But have you filed the application for implement? On 25/2/2025, there was an order that you would file an application for implementing the executing agency or contractor.
yes, that is.
That has been done,
Yeah, that already done.
already done.
Mm.
Which order? Have you filed amended cost title? Okay, yes, you have done that.
Mhm.
7-3, right. They have appeared or not? No, the newly implemented respondents has notice been issued or
Yes, my lord. Already issued.
when?
Come for the third time, 7-2.
Yes, you have taken steps.
Yeah, step. I have already taken a
Anybody has
step.
appeared?
Yes, already I have taken it.
for private respondent, no one has appeared.
Any office note? Was still awaited. You have just taken has furnished taken steps 11-4, 11-5. Send the office note. Send, peruse the office note dated 13.
My lord, as per High Court order that
Wait, peruse the office note dated 13/5/2025.
Hmm.
As per which service report upon the respondent numbers 10 to 17 are still awaited. Full stop. List after 4 weeks along with press service report. In the meantime, the official respondents are directed to file their response.
My lord.
my lord, I would like to pray that till such period that process and payment of the bill may be stayed. Otherwise, it is a
Who's respondent number 6?
That's phone number 6. I am, my lord.
You are supposed to file an affidavit
RD.
Yes,
regarding why, what is the, and depending on your response,
yes, my lord.
the prayer for stay would be considered.
yes.
That is why I have submitted. My joint director has some spontaneous, my lord.
Is there any?
Already-
Is there any move on your part to pay any bills recently?
No, my lord, there is no such any moment until the project is completed, there cannot be any part payment. my lord.
On the next date, the aspect of the payments made and pending bills are also to be brought on record. We'll consider that. But work normally will not like to stay and work of public importance. You may have some differences, but staying a work will not help the public. Let us see.
This is only
Yes.
for security.
We will fix a date.
Yes.
List on.
Short
Don't
date, my
don't
lord.
say 3 or 4 weeks, say 3 weeks, huh? Short date. Today is
Today is my lord 14.
14th.
Please, my lord, if you do
We'll have it on 2nd of June,
2nd of June, my lord.
2nd June.
My lord.
Yes.
In the meantime, my lord, requisite copy may be furnished to us, my lord. So that
He has
we-
given, I think.
Yes. All the copies.
No, my
are
lord.
furnished.
Extra copies.
No requisite copy, my lord.
Oh, please give extra copies.
Okay, today itself.
The learned counsel or the petitioner has undertaken to serve extra copies of the writ petition to the learned counsel appearing for the respondents.
Obliged.
Give their names, huh? Harish Navaman, teacher.
My policeman.
Yes.
Now, my lord, finally the extension pleading has completed and matter is ready for disposal.
Yes.
Now, before come to the my lord, document wash, the nutshell of the present PL is, my lord, that the land of the library, which was allotted by the government of Arunachal Pradesh for the department of the library, has been doubly allotted to the private respondent here in this present case. And thereby, we come to know that the district library is trying their level best to evict this person from the allotment. And finally, we come to know that despite of the eviction, that the compromise has been met between the department and the private respondent, whereby the septic tank of the building is established within the office premises, and that has been established as a public-private partnership property. So in such a way, this has been disposed from the respondent number 4, that is the state officer, by saying that they are not ready to take up this matter on the ground that land has been allotted to the private respondent. But our basic question to raise this matter is, this is the first time ever everybody find that the entrance of the government office has been, my lord, allotted, and thereby the building has been erected, and the office department are allowed to go through the, my lord, come to the passes through the one single room of the, my lord, private respondent. Therefore, my lord, basically, first of all, it was questioned that how this doubling allotment was happened. So while questioning to this particular question, how this allotment had happened, the reply from the government is that this was, since the Deputy Commissioner Capital Complex was not made as a party, therefore they are not responsible. Later on, we met the Deputy Commissioner Capital Complex was made as respondent number 6. And again, that said that this allotment was done during the time of, at the time when this Deputy Commissioner was at the UPIA. And thereafter, my lord, UPR respondent number 8, Deputy Commissioner of the UPR was also made as respondent number 8, my lord. But however, despite of that, my lord, this no answer has been, my lord, received from the department, government, that how this doubling application was made. Now, finally, my lord, this honorable court has, after hearing for a certain extent, it has come to the conclusion that the order passed by the state officer, wherein they have decided not to proceed against the private respondent, has been quashed by this honorable court, and a specific order was passed so that they should come with the region. And thereby, my lord, the proceeding, the second subsequent proceeding was called for, and that was required in the, my lord, original. So I hope this original should be, my lord, in the court, my lord, before this honorable court. Because in the last occasion, it was adjourned only on the requirement that this original proceeding is required, my lord. Now, my lord, come to the facts, my lord. First of all, I would like to demonstrate that the district library,
First you tell us, who are you?
my lord, I am the social worker. I am the president of Arunachal Jurist Forum, my lord.
Arunachal
My lord, Arunachal Justice Forum, my lord.
Justice Forum.
My lord. By doing so, my lord, the social activities, therefore, my lord,
You are a registered association,
my lord, not registered, my lord.
not registered.
No.
That doesn't matter. What do you do? What are your activities?
My lord, I'm
Apart from filing PIL,
while doing filing something, my lord, there are so many filing, my lord, PL in my name, my lord. So, my lord, basically, I am, my lord, keeping eagle eye over the, my lord, activities of the government, wherein, my lord, the general peoples are being deprived,
what
my
do you do for a living?
my lord.
There are two petitioners. What do you do for a living?
My lord, this, one is the president and the other is
No,
my
no.
lord.
What do you do for a living? What is your source of income?
My lord, other than this, my lord, in my individual life, my lord, I am doing some petty work, my lord, petty contract, my lord.
Petty contract.
My lord, because I am not a big person, my lord, class 1, class 2 contractor like that.
And
But
the-
I am busy, my lord, I am confined and I am busy in, my lord, this social
no,
activities,
you have to live also.
my lord.
You have to work, you have to live also. You have a family also. What do you do for a living? We're just asking.
Yeah, my lord, that is my answer, my lord. Oh, I am doing some
Contractor.
not as a, my lord, registered or recognized contractor.
Not
But
no, what do you do?
then, my lord, I am doing some petty contract, my lord.
Petty
But
contract.
yes, my lord.
And the
Just
now,
to-
as per petition number 2,
my lord is also same person, same, my lord.
not
Same,
same,
not the same person, my lord. Same situation,
petty contractor.
my lord. Because we are, my lord, engaged maximum of time, my lord, we are engaging in these social activities.
Where do you stay?
My lord, I am staying here at Itanagar, my lord.
Both of you.
My lord.
How many members are there in this justice forum?
My lord, sorry, my lord, to that extent, my lord, I have not got through. I say personally, I say, my
No,
lord.
no, you have to be given instructions that you are the president and the general secretary of Arunachal Pradesh Justice Forum.
My lord.
And you are doing very good works, laudable works. But how many members are there? Any idea? No idea.
My lord, no idea. My lord, however, my lord, I may assume that at least, my lord, the requirement of this, all the process.
No, we are not saying that only an association can come. Individually also you can come. There is no problem. We are just trying to have an idea. Who
Madam.
are you? Why? What is your? Just to rule out any other motive in filing the PIL. Now, what is the cause of action? What are you? What are your grievances?
Now, here in this, my lord, grievance, just, my lord, directly, my lord, demanding from this honorable court to eviction of this building erected by the private respondent, my lord.
Private respondents are directed what building?
The private respondent has erected the building, my lord.
Which building? Which building?
My lord, The picture of the building is given,
No,
but
no, what is the nature of the building?
my lord, the commercial building.
Where?
My lord, there the same is located at the
Where?
Naharlagun Hatimata, near the district library,
Near district library.
my lord.
This private respondent is number 6.
Private respondent number 5 is the wife and the 6 is the husband,
They have constructed
my lord.
5 and 6.
Yes,
This commercial construction is a private construction.
my lord,
Private construction.
purely private construction.
Now, no, the construction, is it a government building? No,
No,
it is their private
there
construction.
is still private.
So it is on a piece of land owned by whom? Who is the owner of the land? Over which?
Now, my lord, recently I come to know that initially this owner was the private respondent number 6.
Yes.
Now, by this affidavit, additional affidavit recently, I come to know from the filing by the government that the owners of the is the private respondent number 5, 5 of the, my lord, members of
So there is no
Parliament.
dispute regarding ownership of the land.
my lords.
So what are your grounds of challenge?
My lord, basic challenge is that this should not have been allotted because this is the prone of the government and government office. And at the same time, this government office was already allotted to the government. Therefore, there is doubling in the allotment. This should not have been happened.
What has been allotted? You say that a commercial building has been constructed
We
by
did,
the respondent numbers 5 and 6 over a plot of land owned by the respondent number 5. Now, what is the allotment? Allotment of what?
allotment means, my lord, our basic contention is this allotment to the private respondents,
No, what allotment? They have constructed
government allotment, land allotment, my lord.
land
Yes, my
allotment.
Plot of the government plot of the land that has been allotted
Allotted when?
by the, my lord,
When was it allotted?
1995 percent,
1995.
95. Yes, sir.
And you are challenging this when? 2018.
my lord.
Now, allotment of 1995, how have we explained? From 95 to 2018, there may be a delay for reasons we have to explain.
Perhaps, my lord, to that extent, my lord, I admit it. But, my lord, when we come to know, my lord, when we come to know that the district library is trying to, my lord, evict the private respondent, then only we come to know that this allotment was done, my lord.
Who is trying to evict? District library?
District library, that is, this land allotted to the private land is within the allotted land to the district library. That is our contention. Therefore, this should not have been allotted to the private respondent. Particularly, this allotment was done to the prone of the, my lord, office.
Are you trying to suggest that the land which were allotted to the respondent number 5 in 1995 was actually land of the district library?
Exactly, my lord.
And it was allotted in 1995 and you came to know about this much later.
My lord.
And therefore you have filed this.
My lord. That is the, my lord, actually, this is the crux. Now, in consequence, my lord,
So, but won't this be a private dispute? How are you taking this cause as a cause of the public?
because, my lord, the district library is the property of the public, my lord. Now, district library is in such a way, my lord, in order to enter that
Who is the
district
owner
library,
of the district library? Under which department?
library, my lord.
Anyone appearing for library department?
Lordship, I'm
What is your stand? Has your land been allotted? Land been diverted to somebody else?
no, Lordship, in additional affidavit, we have said there is no more, we don't have any grievance now. There was earlier there was a problem of entry. Only that was
No, the basic contention of Mr. Modi, that land allotted to district library, a part of the land was allotted to the private respondent.
no lordship. In lordship, the private respondent at that point of in 1995, he was allotted. He was allotted 300 square meter at that point of time.
Okay, 300
Now-
square meter.
But now in between they have so given some additional allotment the government has.
Hmm.
But then at that point of time, 300 square meter, and then the library had 3,895 square meter allotted in 1982 also.
1982 library.
Library is little bit inside, and then lots of in the additional affidavit we have a
Library, what is the land to the library?
3,895 square meter lots of
3,000?
800 lots of in
800?
different places is the they have narrated it differently lots of 3,895 square meter.
Square meters?
Yes,
Okay. Now this land is intact or not?
lots of they already have a boundary wall
Campus?
erected. Yes, long before. As per the secretary, library secretary's lordship affidavit.
Your land is bounded by a boundary wall.
Yes,
Okay.
yes. They
Now,
are
what is their grievance? First grievance, which you have understood, is that
only
land,
grievance was the
land
entrance.
allotted to, no, the first grievance is that land allotted to the library, that one part of the land was allotted to the private respondent.
Not part, but just because the library is inside, the private respondent is allotted in the front of the library. So the entry point was little bit lots of, it was disturbed. So they have made the entry, proper entry now after the their complaint. And then the septic tank, the which they are saying, it has been agreed upon by the secretary library and the private respondent. They have settled it and made it PPP, public private
Partnership.
public private partnership,
Regarding what?
septic tank that will be used together also. Only with regard that they had lots of grievance. Now, all that has been settled and we have filed a additional affidavit lordship as per direction of this honorable court lordship. The last direction of this honorable court is on lordship, but lordship will see at 24/5/2024. Accordingly, we have filed this latest additional affidavit lordship, wherein everything has been settled lordship. Secretary library has also given statement, and then secretary land was also directed to give statement. He have also give statement. We have enclosed everything here, lords. The direction was given to the estate officer Itanagar. So he have a lordship in my additional affidavit lordship. In my additional affidavit, page 139, lordship. Page 139, additional affidavit. This is to bring in records of the proceedings only, lordship. Lordship got it?
Just a minute, please. There are complaints. Complaints by the district. What is the nature of the activity of that now?
Now, yes, one big, this one open is left, Lordship. Yes, Lordship. No, it's there, Lordship. It's there, Lordship. We have given this one also, Lordship. And Lordship, diligently the estate officer has complied the honorable court's order, and accordingly we have filed everything is here. The additional affidavit, Lordship. Oh, Lordship, regarding, oh, Lordship, yes. Lordship, at page 39, Lordship, kindly see. Yes. 139. Lordship, may kindly see here. Here, Lordship, 139. 139. This is the statement by the secretary, written statement on behalf of respondent number 1, Secretary Land Management. Lordship. This is at para 6, Lordship. You will see here that is in the instant case the honorable court is directed to address 2 issues, that is construction of septic tank by Srimati Yamut Gaur, that is private respondent, on the premise allotted to District Library and Information Center, to approach path to District Library and Information Center, that on perusal of documents and records, it can be clearly ascertained that there was an agreement between so and so and the director Public Libraries of AB to convert the present septic tank to PPP model. In 7, Lordship will see 8 per Article 299 of the Constitution, which requires that contracts and assurance of property made in exercise of that power to waive any right over government land shall be executed on behalf of governor by such person and in such manner as he may direct or authorize. Therefore, the appropriate authority to execute any agreement in such case would be the concerned secretary of the department. As such, the settlement made between Srimati Yamut Gaur and the director Public Libraries and Information Center humbly submitted it was not entered with the appropriate authority, and there is no government approval on the same. But then later on it was sent to the land department and they have Lordship. In para 9, they have said that this. Mm. Yes, Lordship. In para 9, Lordship, they have said they have to be sent to the. Yes, yes, yes. This is, Lordship, they have sent, and then accordingly, Lordship, even the additional allotment was given in 2023 to the private respondent. Yes. Lordship. Yes, Lordship. Yes. Yes, Lordship. Yes. Lordship, this is the proceeding by the estate officer, this additional affidavits. This is written as statement by this one to the estate officer, given to the estate officer. Lordship, in the beginning. Lordship, I was to bring this additional affidavit before this honorable court only. So, and then in addition to that, the honorable court has directed me to produce the file. Lordship. 2018 file of the earlier chief estate officer. So I have brought the report to the last order, Lordship, the latest order.
And my lord, I am to reply this particular issue. This is just what has been read out, my lord. Now, my lord.
Lordship, in the same additional affidavit, Lordship, statement of the secretary library is also there. Yes. Lordship. Yes. Maybe sent to the. Lordship, that part. Lordship. Yes. Lordship, in the additional affidavit itself, the photographs are annexed. Lordship can see it yourself, Lordship. The court can see it. No, Lordship, from the beginning, it was page 145, Lordship. 5. 145, 146, Lordship. Secretary Libraries statement also, Lordship, they have no grievance and that there is no more encroachment now. With the what's the time?
My lord. Yes, my lord, this. My lord, this can be known from the order that it passed by this honorable court, an order that the 24/5/25, wherein, my lord, this approach library possesses, my lord, 34.8 square meter, my lord. 34.8 square meter. That's, my lord. Approximately, my lord, 3 meter, 34.8 square meter, my lord, including all. Yes. Where is, my lord, approximately 3 meter? It is, my lord. Hardly, my lord, this, my lord, is hardly JCB and the others big vehicle cannot enter there, my lord. This is only the single way to enter to the library, my lord. And this can be visible. No, my lord, just referring, my lord. Sometime, my lord, since the library is the office, my lord, certain big, this load carrier by the big vehicles are also required, my lord. But that is, my lord, the subsequent issues. The main issue is, my lord, that first of all, my lord, this has been, my lord, find out that despite of questioning the allotment, my lord, allotment was for 300 square meter. Whereas it has been found that, my lord, this building was constructed 393 square meter, meaning, my lord, the excess occupation of the area is, my lord, 158 square meter, my lord. So, my lord, there has been despite of the, now, my lord,
And
during,
it has been made to 393. If it is 93, then how it is 158 additional? It should be 93 additional.
my lord, this calculation has already been, my lord, in their additional affidavit also, and as in the order that the 24 May 2024, my lord, this honorable court has already found, my lord. Thereby, my lord, during pendency of this PL, again, the excess meter of 158 square meter has been allotted to the private respondent or PAC, whereas she has already constructed the building since before 2017, my lord. Meaning, thereby, my lord, if, my lord, this type of allotment is allowed, meaning thereby the condition will be, my lord, the precedent condition will be constructed the illegal building, and thereafter government is compelled to allot the, my lord. So what is exactly, my lord, they showing in this case, my lord?
And madam, what is this PPP? What is PPP got to do with resolving a septic tank? PP is a mode of working something.
And
How do you resolve the septic tank issue?
Septic tank, Lordship, is the library also have no grievance against this, Lordship. They are also using.
my lord,
The library may not have grievance because of obvious reasons. We are concerned. How do you have a septic tank on the way to the library?
No, it was already there, Lordship. They have built,
Who built the septic tank? Library or the
no, the
private
private
respondent? Then how do you build a septic tank in front of the library? And how do you address it by PPP? What is it? PP is a mode of working. It will not transform the septic tank from some to some other thing. You cannot go on constructing anything and everything you want.
My lord, to this extent, this was already passed on.
So what is your answer to this septic tank? Just see your answer. That it has been done through a PPP. What is a PPP? What have you done? You do it by PPP or anything. We are not very too much concerned. But what have you done to address the issue?
Lordship, this is the proceeding only, Lordship.
No, you have to tell us. You are before us to answer.
Lordship, let's see the secretary libraries, Lordship, then statement.
Yes, page.
Lordship, just a second.
Secretary library stand, we may not be very much. He should have been the first to make the complaint. What was we doing?
In fact, my lord,
Lordship, 42,
142.
yes.
Yes, please.
One fifty-two, Lordship. Additional affidavit.
What is this 142?
142, Lordship, here, the secretary libraries, Lordship, statement is that, reply is that, whether the question, whether the total area was a compromise adjusted as per requirement during construction of the present boundary wall lot. He replies that total area of land allotted by government of AP by so and so 1980 is established as per records available in the office of so and so. Lordship. In this regard, the undersigned verified and measured land in question with measurement tape on spot by measuring the total area of land allotted to Department of the established fact is as follows, Lordship. He says that there is no enforcement, Lordship. And then both the parties had a problem regarding entry gate and a septic tank in which the matter is resolved in the recent past. However, there was no complaint among the other people settled in the northeast and south boundaries as per records available in the office. Whether any other complaint of encroachment of library land exists other than the complaint letter addressed to Srimati Yamatgao by the District Library and Information Officer by number 2017, dated 4/4/2007, wherein it was alleged that respondent's building is posing obstacle to free flow of loaded trucks and JCB into the library campus and construction of unauthorized septic tank inside the premises of the branch library. Reply, Lordship, here reply. No, there is no other complaint of encroachment of library's land other than complaint letter addressed to Srimati Yamatgao by District Library and Information Officer Nahalaghan, available in the Office of Director of Public Libraries, Itanagar, 8 per record within the government allotted land. Regarding building posing obstacle to free flow of loaded trucks and JCB into the library campus and unauthorized septic tank inside the premises of branch library Nahalaghan, Srimati Yamatgao and the public library department sorted out the said issues and thereby no problem exists. The respondent to corrective measures, be it free flow of loaded trucks or the septic tanks. No problem exists on that. Also. This is the Secretary Libraries Lordship statement. Reply.
Secretary library is so. Secretary Cultural Affairs. This parawise comment which you are just reading, madam, has it been put by way of an affidavit in this proceeding, court proceeding?
Yes, Lordship.
Which paragraph? Which affidavit?
Lordship will say this is by the estate officer, filed by the estate officer, my additional.
No, this is the written statement, parawise comment. Where is the affidavit in this court?
Lordship, this is proceeding of, this is the proceeding before the estate officer. Before him, they have appeared, Lordship.
We have understood, madam.
Eight per honorable court's direction.
Madam, where is the statement before this court mean by way of an affidavit? By this cultural department secretary. Let us see his affidavit.
Lordship, before
this-
that,
see,
from
this-
NHR one
Madam-
is the,
Please,
Final-
please understand, we are making ourselves very clear. These documents which you have tried to refer
Lordship,
is a part of the additional affidavit filed by the
estate officer.
extra assistant commissioner and see at page 105, he has described himself. He is the extra assistant commissioner in the office of the EAC, Arunachal Pradesh, Naharlagun. And he has simply enclosed certain documents. Correct?
Lordship,
Now, this document includes a parawise comment of the Secretary of Cultural Affairs.
Lordship.
The Cultural Affairs Department is a party here in this proceeding.
Lordship,
Cultural, no.
Lordship will see the honorable court's direction, Lordship.
No. This statement which you are trying to refer and rely, that the cultural secretary, department secretary has put by way of a written statement or by way of a parawise comment
Before the estate officer,
before the state officer,
yes.
he is required to make such statements in this court by way of an affidavit.
Not here, Lordship, before the estate officer.
No,
has
he is
filed-
required to make an affidavit before this court. His statement before the estate officer, what evidentiary value will it have in a court proceeding?
But then Lordship, honorable court's direction, to me was, Lordship, to bring in the record of the proceeding of the estate officer and file additional.
We are not finding fault with you. We have put those on record. That is okay.
Hmm.
We want the same statement by way of an affidavit in this proceeding.
Lordship,
If it comes as a way of an affidavit, we can give regard to such statements. Now, we have put this as a part of the additional affidavit by only which certain record documents have been placed before this court. Now, this deponent of this affidavit is not the deponent of that parawise comment. He is a different person. He represents one of the department of the government. Let him
Lordship.
file an affidavit. Who are the parties here?
Lordship,
Mr. Modi?
Lordship, see, that may kind of.
Yes, yes.
Babu किसी को? Babu किसी को? Lordship, here, Secretary Commissioner Land Management is there. Estate officer is there. And the chief secretary. Library is not the part here.
And cultural affairs?
Cultural affairs, he is the secretary library, Lordship. Secretary library and cultural affairs.
Now, why we are asking you this question again and again?
Yes,
Because you are trying to rely upon a parawise comment made by the secretary saying
Yes.
that all matters have been sorted out.
yes,
That is in the form of parawise comment, not as an affidavit in this proceeding. Have you understood?
yes. Lordship, he is not-
That record has been brought before us by way of an additional affidavit filed by the EAC, not by him.
Lordship. He is not a party in the main writ petition, and then Lordship, actually the query is on, Lordship, the agreement made between the director libraries and the private respondent. So the secretary was called for this in the proceeding also, before the estate officer. And it but the 24/5/2024 direction of this honorable court, also the estate officer has reopened the Oh. 'Not so. Lordship, may kindly go through the honorable court's direction on 24/5/2024 again. 24/05/2024. (24/05/2024). Yes, Lordship. According to this additional affidavit has been brought in record. Brought. Then Lordship direction may be given. Let's see.
I'm for 5 and 6, man. Private respondent, man.
1 to 4, Lordship.
Other, otherwise, Lordship, the petitioner himself, while filing the PIL, he annexed a photograph showing the path, where the entry is there, that, and everything has been cleared by the state officer. According, kindly appreciate, if there was, if I was not publicly conscious, yes, but.
Estate officer, Lordship may, because
State officer.
direction was given. He acts as a estate officer also, Lordship. In this case, he has acted as estate officer. The proceeding. Lord, can this matter be taken up before the same court? May I pray, because other courts gives sees it in there. This is too much, of course, but. Right. And Lordship, that record, if not required.
Item number 2.
May it please your lordship. So this is against an impugned transfer order, my lord. The impugned order of transfer, my lord, the typed copy is at page 66, my lord. Writ appeal, my lord. There was an interim order in the writ petition, my lord. I was the petitioner, my lord. Petition has been dismissed. Though the interim order was in my favor, it has been vacated, my lord. Honestly,
No, my lord, I am for private respondent.
You're on caveat.
Yes, caveat.
the impugned order of transfer, my lord, if my lord will find it at page 66.
66.
66, my lord.
You had challenged an order of
I had
transfer.
challenged that order, my lord.
Who are you?
I am Taban Tabing. I am the executive engineer at Boleng division of the
Taban Tabing.
Tabang Tabing at serial number 2.
2.
Serial number 2. Serial number 2, it should be serial number
Should be
1.
serial number
Serial
one.
number 1, my lord. There's an
matter.
error in the typographical error in the
Doesn't matter.
typography, my lord.
Petitioner.
Taban Tabing.
Tabing.
I have been
You are an executive engineer.
executive engineer in the Boleng division. I have been transferred
Which department?
urban affairs, my lord.
Urban Development Department.
Urban Development Department.
UDD.
UDD. But here in the transfer order, it is mentioned Department of Urban Affairs, my lord.
Urban Development and Housing.
Yes, my lord.
UDNH.
UDNH.
Boleng to?
Boleng to Office of the Chief Engineer.
To Itanagar.
Itanagar.
Yes.
And
Then
the private
it was
respondent,
dated what?
my lord,
27th October.
27th October, issued on 29th of October, but I was served later.
Oh.
On 29th of October, issued on my lord. On the next page, lordship will find.
Then?
The private respondent is at serial number 2, Tada Relum.
Yes.
She is shown, my lord, as SW1, that is Supervisor of Works 1, Office of the Chief Engineer, Urban Affairs.
Private respondent number?
Private respondent number 3, my lord.
And this is a byway transfer. On her place, you have been.
My lord.
Okay, she is known as what? Yes.
My lord.
Yes.
My lord will see posted to the third column, posted to, insofar as I am concerned, I am posted to the Office of the Chief Engineer.
Yes.
And she is posted as EE, Executive Engineer, Boleng Division.
Yes, byway transfer.
Yes, my lord. And thereafter the remarks.
Yes.
As against me, there is no remarks. But as against the private respondent, it is vice tabangte being transferred. It's a transfer, I understand, my lord.
Okay.
Why I'm pointing out, my lord, if my lord comes to the page thereafter, that is page 68,
How many years did you serve with?
my lord,
Oleg?
4 years.
4 years.
4 years. I'm not on that, my lord.
Okay.
I'm on the other parts, my lord. If my lord comes to page 68,
68. Yes, please.
this is an order dated 22nd of March 2023.
Hmm.
I'll read the order, my lord.
Hmm.
In the interest of public service, the governor of Arunachal Pradesh is pleased to order the following assistant engineers to hold posts of executive engineers in their own pay scale as indicated below. The private respondent is the serial number 9, Tada Relom, assistant engineer, CCD. She is posted as in charge SW, Chief Engineer's Office, Itanagar. Now, if my lord once again comes back to the impugned transfer order,
What is SW?
SW is supervisor of works. Surveyor of works. Surveyor of works. Sorry, madam.
Yes,
Her substantive posting, my lord, is that of assistant engineer.
yes.
And she is merely holding charge of the post of surveyor of works, which is equivalent to executive engineer.
Yes.
Now, if my lord comes to the impugned order, lordship will find that she is transferred not from her substantive post, but from the post, the charge of which she is holding in addition to her post as assistant engineer. This is the illegality which has been, in my humble submission, my lord, was not given its due credence by the learned single judge.
Yes.
That is why I'm before lordships. And thereafter also, if lordship comes to page 69, there's a list of executive engineers of this urban development and housing department, page 69. The assistant engineers, the private respondent is at serial number 26 of this list of executive engineers. There is no date, my lord, in this particular list, but this is an official document.
Yes.
Then page 71 is the list of executive engineers. I am at serial number 36. Oh, we are at serial number 4. We are, sorry, my lord, we are at serial number 4. And serial number 36 is Tada Relom, the private respondent. Lordship will see the status in charge. Serial number 36, the last column, status in charge. So therefore, my contention before the learned single judge is, my lord, that a person can be transferred from its substantive posting, not from the additional charge which that person is holding, my lord. That is
Is it additional charge?
it is additional charge. The order is there, my lord, which lordship has read, page 68. Is whole charge of the post of executive engineers, but the substantive post, page 68. And as well as,
Let us see the order.
sorry, my lord,
Let us see the order passed by the honorable single judge.
single judge, my lord. Single judge's order, my lord, is from page 134. Starts at page 135.
130.
135. But before that, my lord, could I place one judgment? This is a judgment which is holding the field. This is exactly on the same point, my lord. This is taken from the High Court's website, my lord. This is a judgment. It should be an order, my lord, dated 28th of September 2016 in WPC 257 of 2016, passed by this bench, my lord. It's of a single judge, my lord. My lord may come to the second page, para 8. The printout is like this, my lord. It has been taken from the website. That's why.
What is the name of the case?
This is Nyapung Konya versus State of Arunachal Pradesh.
Where do you get the name?
My lord, this is from the website. The writ petition number is there, my lord. And I'll get a copy of paragraph 8, my lord. As regards the 4 years of service which I have already undertaken. This was similar here in this case.
Okay, no, where is what is the side, ratio you want to?
My lord, the ratio is a person holding a substantive
Where,
post.
where?
My lord may come to page para 16, my lord. Before the ratio, the issue which has been,
Okay, answer it.
My lord.
Come to the answer.
my lord, para 17, my lord. No doubt transfer and posting of government servant is within the domain of the administration.
Yes.
My lord. Courts are ordinarily reluctant to interfere in matters of transfer and posting, save and except in cases where there is breach of statutory provisions or where malified exercise of power is demonstrated. Court may also examine a challenge to an order of transfer on the ground of violation of Article 14 of the Constitution of India. It is also true that a government servant cannot insist that he be posted to a particular station. It is for the administration to decide where to post whom. Having said that, it is also to be noted that where there is a case of interstate transfer, the transfer is to be carried out within members of the same cadre. Admittedly, in this case, petitioner belongs to the cadre of executive engineer in the PHE and WS department, government of Arunachal Pradesh. On the other hand, respondent number 4 belongs to the cadre of assistant engineer in the same department. As per service hierarchy, post of assistant engineer is subordinate to the post of executive engineer. By an order dated 14/12/2015, the respondent number 4 and 14 others who are all in the cadre of assistant engineers were allowed to hold charge of executive engineer on temporary basis in the scale of pay of assistant engineer without any extra remuneration. It was mentioned that such functional charge of executive engineer was purely a stopgap arrangement and would automatically be terminated as and when the regular executive engineer is provided, further clarifying that holding of additional charge of executive engineer would not confer upon those 15 assistant engineers any right to claim regular promotion to the cadre of executive engineer. On that basis, the respondent number 4 was posted in the office of the superintending engineer, PHE and WS department, Yachuli, whereafter the impugned order of transfer to Daporijo is issued. Be it stated that, my lord, may come to the next paragraph of para 19. A closer scrutiny of the impugned order would go to show that the respondent number 4 has been described or referred to as executive engineer, and as executive engineer, he has been asked to take over charge from petitioner Daporijo. The fact of the matter is respondent number 4 is not an executive engineer. The substantive post is assistant engineer. By the order dated 14/12/2015, he was only allowed to hold additional charge of executive engineer. The concept of allowing additional charge would presuppose holding of substantive post to enable taking over additional charge. As noticed above, substantive post of the respondent number 4 is of assistant engineer, and he could have been transferred only to a substantive post of assistant engineer, in this case at Daporijo. Only after taking over charge in his substantive post of assistant engineer would the respondent number 4 be able to hold the additional charge of executive engineer if the exigencies of service so require. An assistant engineer could not have been and cannot be transferred to the post of executive engineer. Moreover, the sheet anchor of the respondent number 4, that is order dated so-and-so, makes it abundantly clear that he would continue to draw the salary of assistant engineer. It is not understood as to how respondent number 4, by holding post or the office of executive engineer at Daporijo, would draw the salary of an assistant engineer. Such an arrangement, as noticed by the government to him so-and-so, may reflect gross administrative indiscipline. As noticed above, transfer of the petitioner has got intertwined with the transfer of respondent number 4 as executive engineer. Since it is a transfer inter se and cannot be adjudicated, dehorse the transfer of respondent number 4. This is, my lord, exactly the same case here, my lord. And this particular judgment has been followed in other cases, my lord. There's a reported, sorry.
Where is the impugned judgment?
My lord, from page, my lord, 135 is the operative portion. Oh, sorry, my lord, is the judgment. The operative portion, my lord, is from para 18 at page 140. The learned single judge, my lord, was of the view that since I was there for 4 years, that is why this judgment was, the impugned order was passed, my lord, but from para 18, page 140, my lord finds.
140.
140, my lord.
Yes.
Para 18. Law is well settled that transfer and posting of a government employee is within the discretion of the government. In the case at hand, the impugned transfer order was issued in public service, in the interest of public service. Further, the petitioner has completed more than 4 years of service in Boleng UD division, whereas normal tenure of posting is 2 years. Moreover, this writ petition was filed by the petitioner on 21/11/2024 and the interim order passed on 22/11/24, whereas the respondent number 3 was already relieved from the office of the chief engineer on 1/11/24 and she joined at Boleng division on 11/11/24. On a perusal of the materials before this court and the parties and considering the entire aspect of the matter, the petitioner found that the impugned order of transfer of the petitioner issued by the Commissioner of Urban Affairs, Government of Arunachal Pradesh, Itanagar, respondent number 1, wide order number so-and-so, dated 27/10/24, issued on 29/10/24, transferring him from Boleng UD division and posting him as surveyor of works 1 in the office of chief engineer UD and H at Itanagar cannot be interfered with in the exercise of powers under 226 of the Constitution. Before the interim order was vacated, my lord, the interim order also lordship will find why I'm referring to the interim order, my lord, because it refers to the judgments of the coordinate bench, my lord. Interim order dated 22/11/24. Lordship
Just a
will-
minute.
Sorry,
What were your contention before the single bench?
my lord. I had relied on this particular judgment of Nyapung Konya as well as another, my lord. Lordship may come to para 6 at page 136. Para 6, my lord,
Yes,
page
yes,
136.
yes,
my lord. My lord, the contention of the lordship finds. The contention of the petitioner is that the coordinate bench of this court in cases of Nyapung Konya versus State of Arunachal Pradesh, which lordship has read, my lord, and
Yes,
Hibut,
yes, we've seen.
my lord, the interim order was passed on this consideration. It mu-
Page?
My lord, page, my lord, 84. It starts from page 85. The third paragraph, my lord. Mr. So-and-so, my lord.
Yes.
Mr. So-and-so, learned counsel for the petitioner, while referring to Annexure 3 at page 28, submits that the private respondent number 3 is an in-charge executive engineer and a substantive post as assistant engineer, whereas the petitioner is a regular executive engineer, relying upon the judgment and order passed by the coordinate bench of this court in Hibut Tama versus State of Arunachal Pradesh, submits that since the respondent number 3 is not similarly placed officer in the department, there cannot be interstate transfer between the petitioner and respondent number 3, as the respondent number 3 is not a regular executive engineer. Therefore, the interim order.
Yes, yes, we've
My-
seen.
This was the
We've
ground.
seen.
This Hibutama judgment, my lord, the books I have requested, my lord. This is 2021-1 GLR, page 449. Yes, Hibutama. 449, my lord. It relies on Nyapung Konya, which lordship has read. Para 59, lordship may come to.
59.
59 at page 499. $499, para 59.
Yes.
My lord. Hence, ratio laid down by the learned single judge by judgment on order date 28/9/2016 in WPC 257 of 2016, that Nyapung Konya, which lordship read, there cannot be an interstate transfer between functional executive engineer and substantive executive engineer could be appropriately and the substantive be appropriately be applied to the facts and circumstances obtaining in the present litigation. As have been noted above, respondent number 2, whose substantive post is an executive engineer, having been temporarily allowed to look after charge of superintending engineer SSW in his own scale of pay of executive engineer in the office of chief engineer RWD Eastern Zone in the exigencies of the work of department, could not have been transferred and posted at Pasighat as superintending engineer in Rural Works Circle Pasighat and to replace the writ petitioner who is a superintending engineer, though strictly speaking on officiating basis, but enjoying the pay and allowances attached to the post of superintending engineer and vested with the position and status of executive engineer in the department on being promoted as such in the year 2011 and so and so, my lord. This is the same.
It court does not interfere, man. Now, while approaching before the not a single judge, my lord, they have considered two vital facts. That transfer on request, that's considered as facts, my lord. He was in bowling. The bowling transfer is on request, my lord. That fact was considered, my lord. That he has completed more than 4 years. I think that factor 2 was considered.
No, that has come up in records. 4 years.
Yeah.
The 4 years part, the honorable single judge has taken into account.
Yes, my lord. Now, another had said, my lord, additionally in charge, my lord. I'm sorry, my lord. The private respondent was not given additionally in charge, my lord. He was given, my lord, in charge, my lord, not additionally in charge. In charge, my lord. My lord, it sometimes happens, my lord, officiating in charge, my lord. These are the language twists basically used by the brokers, my lord. They all say, my lord, when you say SW, my lord, SW at par with the executive engineer, my lord. The status is same, my lord. If the someone is in division, you executive engineer. If he is in my lord, chief engineer office, you will be called SW, my lord. So they carry the same status, my lord. Now, the private respondent was given, my lord, in charge, my lord, SW. During, my lord, holding that post, my lord, now, my lord, he was transferred to petitioner place because he has only completed, my lord, 4 years, my lord. Now, the facts, my lord, which my landed privy relied, my lord, that Nyapung, Konya, and Hibutama, my lord, facts are a little bit different when you see, my lord. My lord, I can just, my lord, demonstrate. If your lordship see, my lord, the strength of regular cadre, my lord, we have to see, my lord. My lord, this Hibutama is a case of power department where is regular cadre is available, my lord. But this is a urban development department. If your lordship see, my lord, page number, that's not that said. Page 71, if your lordship Paris, my lord, 71. Has your lordship got it?
Yes.
71, my lord. Top, my lord, list of executive engineer under the Department of Urban Development and Housing, July 2024.
Yes.
Now, extreme, my lord, right, status, regular in charge. Now, if you see the, my lord, how many regular executive engineers are there, man? Your lordship can count 1, 2, 3, 4, 5, 6, 7, 8, maximum 9 numbers, my lord. Now, this 9 number out of total strength of 36, my lord. There are some problems, my lord, the department facing because seniority itself is under challenge, my lord. The method is subject before this court, my lord. And because of that, my DPC could not be, my lord,
my lord, constituted or conducted, my lord. Because of that, my lord, problem, my lord, there is a pendency in the regular promotion, my lord. Now, my lord, can it be, my lord, mandate of, my lord, any either law or, my lord, laid down by any authority that regular can be replaced by regular only, my lord. Under these circumstances, gender basic, can it be a logic, my lord? The female can be replaced by female employee only, my lord. Now here is the same, my lord. The regular can be replaced by only regular, my lord. My lord, my respectful submission is that the law laid down either in that Hibutama, my lord, under that facts and circumstances, maybe right, my lord. But here's the case, man. How many regular, my lord, executive engineer we do have, my lord?
No,
The
there
facts
are,
are different, my lord.
Mr. AG, there are instances where because of certain exigency,
Yes, my
a
lord.
person who is otherwise qualified to hold a higher post
My lord.
cannot be given the regular post in the regular manner
My lord.
and is given in a officiating manner.
Officiating ad hoc, my
But
lord,
the
yes.
question which Mr. Nair is trying to raise is what is the substantive post of the private respondent?
My lord, I'm not denying that, my lord.
Because the other contentions which you are trying to raise, that transfer is an incident of service,
My lord.
there is no malafide, there is no violation of any rules. He has completed 4 years, everything is heavily in your favor.
My lord.
And courts interference in transfer matters, as you know, is very restricted. We are very circumscribed in entering it is your domain,
My lord.
whom to post where. But while doing so, there are two laws which he is relying upon.
My lord.
The earlier one of 2026, what was it, 28?
Hibutama.
257 or 2026. And the second one is of 2021 on GLR 449.
Yes, ma'am.
Those address the issue of this nature exactly.
But facts are different, my lord. You lordship to kindly see the,
But
my lord,
in the-
total extent of the sanction post, my lord,
No,
regular.
that you have pointed out.
Yes,
Out of
madam.
36, only 9 have been.
Only
strictly
9, my
recommended.
lord. Now,
That
10, my lord,
that was
they-
in.
yes, my
But
lord.
in this judgment, which is the matter of challenge, that part, where has it been
But-
addressed?
Yes, my lord. In that, my lord, department, regular cadre was available, my lord.
No, in the judgment which is
My
been
lord. Yes,
challenged now,
my lord.
single judge's judgment, where is this issue been addressed?
My lord, not a single judge said, my lord, since, my lord, the petitioner did not plead any, my lord, discrimination,
No.
violation, mala fide, my lord.
That is okay, that
My-
we are with you.
My
We
lord.
are not on those points.
My lord.
The present point, that is why we have seen whether this point was raised at all before the honorable single judge. We have read the judgment, we have found it was raised.
It was raised, my lord.
And in fact, this earlier judgment has also been placed.
My lord.
And this judgment is purely on this issue. In fact, Justice, in the first judgment, dated, what is the date?
28/9/2016.
16, the restrictive powers of the court has been elaborately discussed before coming at paragraph 17.
My lord.
The wording is that no doubt transfer and posting of government servants is within the domain of the administration. It starts with that. With this prelude, the interferences come.
My lord. But interpret under what circumstances, my lord? You lordship will kindly look into that, my lord.
No,
The ability of the officers, my lord, to
see,
make this post.
this point was answered by a single bench, no doubt, and also been reiterated by another single bench. So
But in
was there
him-
any occasion to take another view?
But in Himutaba case, my lord, this case was caused because, my lord, regular cadre of executive engineers available, my lord. Out of the total sanction post. But here is the case, my lord, out
Okay,
of
okay,
36.
okay. Caveat.
My lord, caveat. My lord, that another issue, my lord, can it be a lookout of the, my lord, the employee, my lord, who should be replaced by whom, my lord? If that be so, my lord, it will be very difficult for us, my lord, in the matter of transfer posting, my lord. The sort of, my lord, consent has to be taken from him, my lord.
No, it's not like that. Person has to be competent.
My lord,
You cannot, yes, if you are questioning that,
my,
we have to ask whom are you transferring? Yes, we can ask you.
yes.
Is the person who is under the
Well,
orders of transfer competent to be transferred?
Competent with the,
Can you transfer an executive engineer with a chowkidar? Interstate?
cannot, my lord.
Cannot.
But,
Why are you answering
Madam-
cannot? Because he is not competent.
my lord, here, my lord, compete is not the issue, my lord. Only
he's raising
issue is,
the-
my lord, regular and
No,
non-regular.
he's raising the issue of competency. He's
Both
not.
are- but my lord, both are degree holders, my lord.
No,
Even
no,
the
not
petition-
degree holder. What is the cadre he's substantively posted in? A masters of engineering can also hold the post of a
My lord,
doctor.
my lord, with due respect, my lord, when you say my lord, cadre, my lord, executive engineer SW is the same cadre, my lord. Now question is only regular and
No,
non-regular.
is he a member of the cadre?
Yes, my lord. Only question is regular and non-regular, my lord.
No, no. In charge cannot be a member of the cadre. Cadre, there is a strength. You need to be appointed through the due process. There may be certain problems in the department for which there is delay in the promotion. We are not also doubting the competency or our eligibility to be appointed in regular course. But as on today, practically, that has not happened. Yes, sir. What is your name?
My lordship, my name is R. Riva, Rimo Riva.
Ariba.
Yes, ma'am.
Okay.
My lord, in this instance, my lord, the respondent number 3, private respondent, he has already joined and taken the full charge of the department on dated 8th of this month, my lord. After yes, and he is now fully taking the in charge of the office,
8th
my
of
lord.
this month.
Yes, my lord. After dismissal of writ petition, my lord.
Oh.
Earlier, he has already joined, but this petition appellant he did not
No,
hand
there
over
was
to
a
the
stay order earlier.
you know, even before that he has joined before filing of the writ petition she has joined the department, but the appellant did not hand over the charges, and so she waited. Then thereafter they filed writ petition, then interim order was passed. Therefore, my lord, after my lord dismissal of this case, my lord, she joined the office and now she is taking full charge of the department. Even his specimen signature has been submitted, my lord, for financial matter, my lord. Further, my lord, I like to take the instant some important aspect of this, my lord. While my lord, petitioner approached this honorable court before the single bench, my lord, they did not approach with clean hand, my lord. They had two facts, my lord. And firstly, my lord, they stated in para number 4 of the writ petition that this been recently transferred to the Bolong, my lord, whereas they've been transferred to the Bolong way back 2020 year, before 4 years, my lord. Secondly, my lord, in para number 11 of the writ petition, my lord, not para, sorry, my lord, para 17, my lord, para 10, my lord, para 10 of the writ petition, my lord. He stated that he is the guardian of the two young child, my lord, Siang Tabing and Taring Tabing, my lord. However, my lord, in my affidavit, my lord, may come to my affidavit, page number 115, my lord, para 17, my lord. 115 of my affidavit, my lord, para number 17. Here, my lord, I have clearly stated before the single bench that the petitioner is not the real parents of the said ward, Mr. Siang Tabing and Mr. Tasing Tabing. Their parents are, my lord, father of the parents is Talem Tabing, who is government driver working under the establishment of DC Siang. And the mother is Srimati Jemmi Tabing, who is working as peon under the office of ED and Housing Department, Bolong, same department, my lord. This, my lord, the petitioner has approached with is misleading the court. Therefore, my lord, honorable bench of single judge has rightfully, my lord, dismissed the matter, my lord. And my lord, further, my lord, in my FARA number, my lord, I have reflected the transfer order also. As for the transfer order, my lord,
Yes, just a minute.
My lord, in reply to my learned friend's submission that she has taken over charge, my lord, I have been granted leave, my lord, by the chief engineer on 8th of May. The leave is till 15th of this month, my lord. So when I'm on leave, someone else has been asked to pull charge. Now, she cannot unilaterally take charge when the chief engineer has already granted me leave.
No, my lord, before
That order I have placed before lordship.
yes, my lord.
Surveyor of works.
Oh, yes. And more on. And there is no dedication of any other or validation of their and order the members are not being right now, and it is the of their such difference maybe only on very specified ground. There was also that the reliance on the earlier business not regular as there is difference in the other patterns in department of concern and those departments which were concerned with the earlier business. We have specifically said that so far as the department of urban development and housing is concerned, out of 30 engineers, only 9
Nice,
are
sir.
on regular basis. And therefore, that's what has to be made from the existing engineering. The department suppose the order is that we the process of the department and addition that on
2025.
is time has learned.
No, my lord, he is taking the charge, my lord. She has joined on 11/11/2024.
Sure.
Yes,
of
already joined on 11/11/2024.
and
Yes, ma'am.
he has also verified that he has learned. He said to earlier on.
11/11/2024 for filing of writ petition. ma'am.
Cards are not available. In a regular manner. He has also placed before us certain orders. Issued by the bank. And technical engineer. One division. That after considering the private commission, we are looking for getting. And we have the water. So, I think the two of that. We cannot really get the fact that on. And order manifesting passport. And the doctor, we. For the applicant. This is for us, an officer by which his plan has been granted. There will be process days from 7/5. 2025 to 15/5 2025, and I therefore. And the way as to how the charge could be given while this plan was on the plan. Period anything we direct that the traffic is equal to the and according to
Any date, my lord, since this is the intra-court appeal, my lord, any date.
For final consideration on
Any date.
2nd of June.
2nd of June, my lord.
Right.
Very well.
Yes, 2nd of July.
2nd of any date, my friend.
Second, my lord.
Second.
Research and indirect. Then let us go on to the demand.
Much obliged, madam.
The records
My lord, instead of Sacco, my lord, because now they are claiming that they are holding their post.
Yes. Yes, ma'am.
My lord. But I was, my lord, I was on leave, my lord. That issue is there. But it's I did not hand over a charge, my lord. So they cannot unilaterally take over a charge. My lord. My lord. My lord,
Yes,
but
ma'am.
the
Today also,
chief
my
engineer
lord,
has
she is
granted me
attending
leave, my lord.
meeting, madam.
My lord.
Yes, ma'am. Much obliged, ma'am.
Okay. Deeply obliged. And pass orders, my lord. Deeply obliged. My lord, yes, the IA was state. My lord, my lord. My lord, deeply.
May I plead your lordship? Well, in this matter, we are challenging the conviction order, your lordship. Ah. Yes, can we appeal, your lordship?
Yes,
Paperwork is there.
The fixed matter, your lordship.
Under 376 read with section 6 of POX, your lordship. But in this matter, there's two IA. One IA is for the suspension of the conviction. Another is for the bail. Another is IA. We wanted to bring some records, your lordship, because there was issue of date of birth. The appellant has filed application before the special court, producing many document which contradicts the records. There's two birth certificate, living. There's school living certificate, and then the first attended school records, which shows that her date of birth is 2002. Whereas as per the police investigation record shows that 2006, and that 2006 was changed in class 9, which is as per the CW1, the court witness number 1, it is clearly recorded, saying that it has been changed when she was in class 9, during that's called LOC. And then accordingly, after the class 10, after the class 10 matriculation, she again, the victim's family again applied for the birth certificate. Yes. No, I'm appealing for the appellants. Yeah, regular appellants. IA we have filed under section 361 CRPC. 361 CRPC. May I read it? Yes. 391 CRPC. Yes. 391, your lordship may see that for may I read that one? The appellate court may take further evidence or direct it to be taken. Subclause 1, in dealing with any appeal under this chapter, appellate court, if it thinks addition. Yes. Yes, my application, your lordship. My application, IA, your lordship. 391, in fact, we wanted to produce one birth certificate. Yes. My lord, yeah, that's what, my lord. My lord, I will just take to in pep. Yes, yes, my lord. My lord, in fact, what happened was that my lord, what happened was that no, my lord, I will just take my lord, I will just take back to my lord, in my application we have filed we annexed a criminal revision petition. That is a page 31, and that is also in our writ petition and the criminal revision petition, page 31, page 31. My IA. Yes. So this was the criminal revision petition dismissed by the concern, your lordship was placed to dismiss the writ petition with direction that we should file application before the special court. That I will just read page. We filed, my lord, sir. Thereafter, no hearing was done, no application was entertained, my lord. Yes, we have annexed here, my lord. We have annexed here, lordship, may see page. Application. Application, my lordship, we have filed in page 16. No, 16. Filing all the documents before the special court. May I read, lordship? To the Honorable Judge Special Court, submission of original documents as per the High Court order dated 29/2023, CRPC such and such. I am writing to bring to your attention that recent High Court order dated such and such, which has prompted me to submit additional evidence in the matter of POCSO case number such and such. As for the aforementioned High Court order, I am enclosing the original documents that were previously enclosed in the petition number 214/23. It is with a deep concern that I inform you that the said documents were initially submitted as part of the aforementioned petitions, but subsequently dismissed, and age was determined by the Honorable Special Court as reflected in the order dated 5 such and such. The documents are vital in determining the age of the victims in the POCSO case number 11 to all significant relevance. Yes. So this was relevant documents. Yes. Yes.
Pronounced on 22nd of September, one day
Yes.
thereafter.
But then there was.
Can you attribute fault with the learned judge? Number one, if you are also, if we are with you on this point, you have to file a proper application.
We have filed a proper application. I will just
Before
come.
this court to adduce evidence in the appellate court. Where is your application?
Yes, my lord. We have filed application, my lord. I'll just take to the judgment, my lord. Page.
No, where is your application? Let us see your application. Let us
Yes,
see your
yes.
prayer.
Yes, my application is a criminal revision petition, my lord.
Not criminal revision. It cannot be criminal revision petition, 391.
My
Where is your
application,
399 petition?
my application has been reflected in the judgment. But then the special court has not considered my application.
Well, that is the point of appeal in the appeal.
Yes,
Paper
yes.
book is there. You argue.
Yes,
the appeal.
yes, my lord.
Argue the appeal. You'd have allowed you 391 if you file it in the proper manner, but not any case. You cannot just come to the appellate court and say that we want to adhere the evidence.
Yes, your lord. Your lord, I'll just take to the page.
Come to the case, merits of the case. Let us see.
Okay, my lord. My lord, before your lordship, my lord, proceed on the this issue on age. Your lordship,
No, we're not hearing the appeal.
yes, your lordship, because your lordship, the age regarding the age determination is already attained its finality by this honorable court only in criminal revision petition. So now, if they are agreed by this order,
Yes, how was the age determined?
age, your lordship, is there in the order, is your lordship. This
No,
is
no,
the
how was it determined? Birth certificate?
birth
or
certificate
what?
and matriculation certificate, both, your
Okay,
lordship.
both of them.
Yes, your lordship.
That
And
means it is in conformity with section 94
yes, your lordship.
of
And
the Juvenile Justice Act.
yes, read
2015.
with section 34 of the POCSO Act. And this was the direction from this honorable court, complying with the order.
Okay,
Learned
we'll
trial
come
court
to-
has.
yes,
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 yes.
let's see.
Then, my lord,
34.
may I submit specifically on the age which has been
No,
determined?
Go serially.
Oh, Lord, I'm blushing. My lord, in this, I'll just go back to the FIR, your lordship.
Yes.
FIR in the page 1.
Single bench may not be possible today because we'll rise at 3:30. We'll visit the new court. Urgent matters, we can have it tomorrow. Okay, because 3:30 and this will continue till minimum. Okay, if this please feels over, then we can have this tomorrow also, but till 3:30 we are here. Okay. And if any one of the bar members want to come to the new building for any suggestion. Not here, you can, they'll request, he'll give the dates, okay?